Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In this video, we continue our in-depth series on the 18 stages of a civil case in India. Today, we will cover stage 14, a critical turning point in the litigation journey. When the court reserves the case for judgment and whether the case can be reopened after final arguments. Let us understand what it means when the judge says, "Arguments heard. Judgment reserved." What does judgment reserved mean? After final arguments are completed, stage 13, the judge may declare that the matter is reserved for judgment. This means the hearing is concluded. The judge will now deliberate privately. No further arguments or documents are normally accepted unless permitted by law. This stage signifies that the court has closed the hearing and has begun the process of examining the entire case before delivering the final judgment. Legal basis for reserving judgment. The process of reserving judgment is governed by various legal provisions. Under the Code of Civil Procedure, 1908, Order 20 Rule 1 requires that a judgment should ideally be pronounced within 30 days from the date of reserving the case, with an extension to 60 days in exceptional circumstances. The Bharatiya Nyaya Sanhita, 2023, though primarily applicable to criminal procedure, emphasizes speedy disposal and reducing pendency, which acts as a guiding principle. High Court rules may also apply and differ by jurisdiction, with many courts expecting judgments to be delivered within 90 days. Time frame for pronouncement. According to Order 20 Rule 1 CPC, a civil court should pronounce judgment within 30 days from the date of reserving the case. In special circumstances, the court may take up to 60 days, but reasons must be recorded in writing. Therefore, once a case is reserved for judgment, litigants can generally expect the judgment within 1 to 2 months. Court's internal process after reserving judgment. Once the judgment is reserved, the court undertakes several internal steps. The judge carefully reviews all pleadings, documents, and issues framed in the case. The evidence on record. The oral arguments presented by both sides are examined thoroughly. Relevant legal provisions and judicial precedents are also studied. After this detailed analysis, the judge begins drafting the reasoned judgment. The judgment is then signed and dated before its pronouncement. Can the case be reopened after judgment is reserved? A case can be reopened after judgment is reserved, but only in exceptional circumstances. The court may reopen the matter if there has been an omission of a crucial legal point by both sides, if new evidence is discovered that could not have been produced earlier, or if the judge notices a judicial error before signing the judgment. An application under Order 18 Rule 17 CPC may also be filed to recall a witness or seek clarification. However, once the judgment is signed, the case cannot be reopened. The only remedy thereafter is an appeal or review. Real-life example. In a 2023 commercial dispute before the Bombay High Court, the court reserved judgment after hearing both sides. However, before pronouncing the judgment, it was discovered that an important Supreme Court judgment had not been cited by either party. The court, in the interest of justice, briefly reopened the matter and allowed short submissions on the omitted point before re-reserving it for judgment. This ensured fairness and completeness in the decision-making process. Advocate's role after judgment is reserved. Once judgment is reserved, the advocate must remain alert. It is important to be ready to submit case law if the court reopens the matter or to clarify any legal point at short notice. Advocates should also prepare their clients for all possible outcomes, including costs, compliance, or future legal remedies. Staying in regular contact with the court reader or registry, monitoring cause lists for judgment dates, and tracking updates on the e-court's website are essential responsibilities. Judgment date announcement. The court may pronounce the judgment in open court, or the date may be updated through the e-court's website or daily cause list. In some cases, parties may receive email updates or certified copies if applied for. The written and signed judgment becomes the final and authoritative ruling in the case. Mistakes litigants make at this stage. Litigants often make avoidable mistakes after the case is reserved for judgment, such as repeatedly contacting the judge's staff to know the judgment date, assuming the outcome based on courtroom interactions, sharing sensitive case details with media or social media, or failing to prepare for the next legal steps such as execution or appeal. Avoiding these mistakes helps maintain the dignity of the process and protects the litigant's interests. Summary: Stage 14 Judgment reserved. At this stage, arguments are over and the judge begins deliberation. The time limit for pronouncing judgment is 30 days, extendable to 60 days with valid reasons. Reopening of the case is permitted only in rare and legally justified situations. The advocate must closely track court updates and prepare the client for remedies. The next stage in the civil process is Stage 15 Judgment Pronouncement. Pro tips: if judgment is not delivered within 90 days, a mentioning application may be filed requesting the court to take up the matter. This is also the right time to re-examine the case file and prepare the client for possible remedies such as appeal, review, or execution. If you found this information useful, please like, share, subscribe, and press the bell icon so you can receive more such important legal videos in time. I assure you that I will continue to provide accurate, lawful, and research-based legal information on various topics through this channel. Your support means a lot to me, so I humbly request you to stay connected with this channel. By joining this channel, you can also receive special legal information and membership benefits. Thank you very much for watching this video. See you soon in Stage 15 of our civil case series. Jai Hind, Jai Bharat.